All right. Good morning, Chair and members. Jose Torres with TechNet. We remain in respectful opposition to SB 378. The bill has a greatly broad definition of online cannabis and hemp marketplaces, and it places a strict liability on them even if they have no direct role in the sales. For example, if an online business explicitly prohibits the sale of and advertisement of cannabis goods, but that online business allows for users to directly communicate with each other, they would be found liable under this bill. Mapping services, search engines, social media, and other digital platforms would be covered under liability under this bill because of just how broad it is. Our TechNet member companies remain committed to ensuring that online marketplaces have reasonable restrictions and policies in place to actively enforce provisions on illicit products, but it creates a large umbrella of liability over companies and businesses with an online presence throughout the state. We appreciate the committee's analysis in recognizing and flagging some of these concerns of the bill being overbroad and needing to be narrowly tailored. We continue to be ready to have such discussions with the author on what that may look like, but as is, we remain in opposition. The bill risks overcompliance and could chill legitimate speech and access to legal products due to the strict liabilities, reporting requirements, and advertising provisions. It is a heavy-handed approach that would hurt businesses more than actually eliminate unlawful cannabis sales. I thank you for your time, but ask that you vote no today.
Thank you.
Good morning, Chairperson Kalra and members of the Judiciary Committee. My name is Shay Gilmore, and I'm an attorney in San Francisco representing exclusively cannabis and hemp operators and investors in regulatory matters, as well as business transactions. I'm here today on behalf of Medterra CBD and a coalition of hemp wellness product manufacturers to express opposition to the bill if it is not amended. SB 378, as currently drafted, would effectively ban the direct-to-consumer sale of most hemp products online, cutting off a vital channel for millions of Californians who rely on these products for their health and wellness. This approach does not distinguish between responsible licensed manufacturers who would adhere to rigorous testing, labeling, and age restriction standards, and the bad actors the bill seeks to address. Instead, it threatens to dismantle California's legitimate hemp industry, resulting in the loss of thousands of jobs and tens of millions in tax revenue, while depriving consumers of safe, regulated access to wellness products that they trust. We agree that the unregulated, intoxicating hemp products have no place in the marketplace. However, rather than an outright ban, we urge the legislature to adopt a balanced regulatory framework, one that includes robust enforcement, licensing, independent testing, strict labeling, and age verification measures already in place in many other states. This would protect public health and ensure not only that safe and non-intoxicating hemp products reach consumers, but that the entire sector that serves California stays viable. SB 378's sweeping restrictions risk driving the hemp industry that manufactures these wellness products even further underground, which will not help alleviate this extreme tax burden that the licensed Delta-9 THC cannabis industry that my colleagues here in support have represented.
Go ahead and finish up here.
Okay, I just want to also thank the committee's staff report pointing out interesting issues about the Dormant Commerce Clause. Obviously, there have been federal court decisions, including the one in New Jersey last year that struck down a state-level hemp restriction. And I also just want to point up for the committee that the definition problem that we have here. AB 45, which is the state of the state, says that you look to the Sherman Food, Drug, and Cosmetic Act, which then tells you to go to the Department of Cannabis Control, which right now, under Governor Newsom's emergency regulations that are going to be made permanent, is an outright ban on all these products. We agree that intoxicating hemp products, which is defined right now to be a non-detect, right? A zero detect. That's kind of unheard of, right? Is not the right. We agree that intoxicating hemp should be banned. Intoxicating hemp products should be banned, but that wellness products that are not intoxicating should be allowed to proceed.
Thank you. Anyone else here in